So, Adam is a sole trader electrician. He's done the work, sent the invoice, and now Bob, his client, has apparently decided that payment is more of a spiritual concept than a real-world obligation. Today, we're looking at the next stage in understanding a small claim for debt recovery from the claimant's side, trying to resolve the matter before going to court. And before we start, this is a general guide only. It is not legal advice. It is not advice on what anyone should do in a specific case. And it is simply an overview of the process for people trying to understand it. So, let's start with Adam. Adam has carried out electrical work for Bob. The lights are working. The sockets are working. Everything is working beautifully, except for one small detail. Bob has not paid. Now Adam may be thinking, right, court, which is understandable. But before getting to that stage, the court generally expects parties to try to resolve matters before issuing proceedings. In simple terms, that means trying to sort it out first. Usually, that means writing to the debtor, setting out what is said to be owed, why it is said to be owed, and giving them a fair chance to respond. That is the general idea behind the pre-action rules and guidance. So this stage is not about marching straight to court the moment an invoice goes overdue. It is not about turning one late payment into a full legal drama, with Adam staring meaningfully into the middle distance while printing forms. It is about making a genuine attempt to resolve the issue first. In Adam's case, that means clearly communicating with Bob about the unpaid debt. The basic idea is simple. Adam would want to make clear what he says is owed, why he says it is owed, and give Bob a fair opportunity to reply. So, for example, Adam might communicate that he carried out the electrical work, that an invoice was issued, that payment has become due, and that the amount remains unpaid. That is the core of it. It is not meant to be theatrical. It is not meant to be threatening. And it is definitely not meant to be a message that says, pay within 10 minutes or I shall unleash the mighty power of county court stationery. The aim is clarity, not chaos. This step matters because the court generally expects parties to try to avoid proceedings where possible. And sometimes, putting the position clearly in writing is enough to move things forward. Occasionally, the debtor pays. Occasionally, they reply and explain their position. Occasionally, they suddenly become very interested the moment they realize this is no longer just another ignored invoice drifting through their inbox like junk mail. And sometimes they continue ignoring everything, which at least tells the claimant something useful. Because that is another reason this stage matters. It helps clarify the situation. Before Adam writes properly, Bob may just be silent. After Adam sets out what he says is owed and why, Bob may pay, dispute the amount, raise some complaint, or continue pretending messages are a government conspiracy. Whatever happens, the position is likely to become clearer. And that helps before court proceedings are started. Another important part of this stage is that the debtor should be given a fair chance to respond. This is not supposed to be an ambush. The idea is not to send one sharply worded message and then issue proceedings before the tea has finished brewing. The point is that the debtor should have a real opportunity to understand what is being claimed and respond to it. So Adam is not expected to chase forever. He is not expected to become Bob's unpaid pen pal. But as a general process point, this stage is about making a reasonable and clear attempt to sort things out before going to court. That is the key principle. And it is worth being clear about what this stage is not. It is not a guarantee that the matter will settle. It is not a guarantee that any later claim would succeed. And it is not advice telling anyone exactly what they should do in their own case. This video is simply explaining the general process. So if we strip Adam and Bob's situation back to basics, it looks like this. Adam is a sole trader electrician. Bob is Adam's client. Adam says Bob has not paid for work completed. Before court proceedings are issued, the court generally expects an attempt to resolve the matter first. That usually means writing to Bob, setting out what Adam says is owed, why he says it is owed, and giving Bob a fair chance to respond. That is the pre-action idea, in plain English. Try to sort it out first. Try to make the issues clear. Try to avoid court if possible, because court is generally not meant to be the first move. It is what may happen when reasonable attempts to resolve the matter have not worked. So the key takeaway from this stage is straightforward. Before issuing a small claim for debt recovery, the court generally expects parties to try to resolve the dispute first. In practice, that usually means a written communication to the debtor explaining what is said to be owed, why it is said to be owed, and giving them a fair opportunity to respond. In Adam's case, that means trying to sort things out with Bob before taking the next formal step, which frankly is still more patience than Bob showed that invoice. And one final time, because it matters. This is a general guide only. It is not legal advice, and it is not telling anyone what they should do in a specific case. It is simply an overview to help viewers understand the general process. And if there is one lesson Bob has accidentally taught us all, it is this. Rewiring a house may be complicated, but somehow chasing payment can still be the part that really blows the fuse. If you want to see the next chapter of Adam versus Bob, featuring the letter before claim, Bob's inevitable reaction, and all the legal drama you secretly came for, hit subscribe and ring the bell below so you don't miss what happens next.